friends, welcome back to our videos where I love to talk about assets, asset protection, and how your assets will show your living, lasting, loving legacy. Today I want to talk about whether I'm automatically entitled to my spouse's property. Are you automatically entitled to your spouse's property if they're deceased? And my answer to that question is, it depends. I know I am like a sounding gong. Every question I say, it depends. But this one, it does depend. First of all, if you're married and all your children are also the children of your spouse, then the assets from your deceased spouse would flow to you. But does it flow to you automatically? Do you automatically own the property because your spouse is deceased? Second, it may be a situation where your spouse has children, but none of those children belong to you. Then in that situation, no. All of his property, you don't get all that property. You keep the community share, your half of the community property, but his half of the community property goes to his children. And while you may have a 1/3 life estate in his separate real property, you only get 1/3 of his personal separate property. And so, no, in that situation, all of his property doesn't go to you, but definitely none of his property automatically goes to you. No property does. You have to do something for that to happen. And that doing is called probate. If your loved one has a will, then the property will pass according to that will, but it doesn't automatically do so. You have to get up, you have to take that will to an attorney, you have to file the application to probate the will, take that will down to the courthouse and get the will probated. Many clients have come to me after the 4-year statute of limitations run on probating a will, and then miraculously they want to sell the house, but they're told they have to probate the will in order to do so. I look at the will, I ask them, when did your loved one pass away? 10 years ago. And unfortunately, I have to tell them, no, my friend, this will is no good. This person now have passed intestate, meaning passed without a will. Therefore, regardless of whether the person has a will or no will, the property does not pass to you automatically. You have to actually probate the estate within the statutory period, 4 years, in order to get the assets in your name. It's not done automatically. Okay? Thanks, friend. Hello, thank you for watching our video. And because you made it to the end of that video, we're offering you our new estate planning handbook. This is a wonderful tool and I'm sure you like it. Go ahead, download the link and let's get learning together.